around without being shady. Who knows her values, who's gone through trials. Her smiles are captured from mouth to mouth. It's not the size of her thighs she worries about, but the pride she thrives to keep that drive. That cinnamon twist. That cinnamon twist. That cinnamon twist. Ladies, can you feel me? That cinnamon twist. That cinnamon twist. That cinnamon twist. Ladies, can you hear me?
Hello, hello, hello. This is your girl Tasha, known to the world as the Tasha Carpenter, but everybody calls me your girl Tasha because when you hang with me, what? It's like you are hanging with your girl. And today, guys, we got some good information about to come to you in here today. In the studio, I have this wonderful guest. I'm going to allow her to introduce herself to you.
Hello, everyone. I'm Nicole Slaughter. I'm an attorney at Berman, Sobin, Feldman Darby in Gaithersburg, Maryland.
Okay, and tell them a little bit more about yourself. What kind of, because we're here today to talk to people about that tough question. How do I plan for my estate when I die?
Okay.
So tell them what qualifies you to be answering the questions that they have. And I have viewers from all over, so we know that there's differences with laws, but some of the stuff that we're going to be talking about can be applied anywhere, right?
Yes.
Okay.
So first, I am licensed to practice in Maryland and D.C. So if you are from any other jurisdiction, I'm giving you information that's based on Maryland and D.C., but you should consult with an attorney in your jurisdiction. I have been an estate planning attorney at my firm now for 4 years. To go a little bit back, I went to Spelman College for my undergraduate and political science major. I went to American University in the District of Columbia for law school, and then while I was in law school, I just so happened to work at a firm that dealt with estates. So I was a law clerk doing that before I became an estate planning attorney, which made it a lot easier to do estate planning because first I had experience in knowing what happens when you pass away. In order to plan for that, you want to sort of understand the estate administration process and what some people call probate.
All right, now that she said a whole lot. That's just like an attorney talking right there. So your girl Tasha, I'm gonna try to act like I act when I came into your office. I mean, I think you did me maybe about a year ago now.
Mm-hmm, yeah.
Okay, so one thing I think that everybody heard of a will. Everybody assumes that they know what a will is,
Yes.
but they really don't know.
Okay.
So if you could just share with us what's the purpose of a will and what's the purpose of estate planning?
Sure. So first, the purpose of an estate plan is you want to prepare for not only when you pass away, but also if you can make decisions for yourself. So essentially you become incapacitated. Many people come into the office because they're ready to plan for passing away, but we want to make sure we cover all bases. So in planning for passing away, that's called a last will and testament. You're essentially designating someone you want to be called an executor, or also what they call as a personal representative. And that person manages your affairs when you pass away. They essentially sign off on all the documentation to make sure that your assets go to the people that you've named in your will. The people that you named in your will would be called your beneficiaries. So everyone assumes, for the most part, that they understand who is going to receive their assets when they pass away. When they come to the consultation with me, some people are surprised that that is not actually the case, depending on where they live. Not having a will, you want to make sure that you're looking at the laws for your state, because you don't want to assume you know what the law in your state is. Your state will have a plan for you. So the question is whether you agree with that plan or not. So having a will allows you to be in control of your plan.
Okay, so what's the recommended age that you should be when you get a will?
Well, I don't look at it as far as age. Because most people look at it as far as, what do I have? If I don't have much, then I don't want to plan. I don't want to pay to plan. I don't look at it that way either. I look at it as if you have anything, then you need to plan for it to go somewhere. So I always say, do you have a car in your name? Do you have a bank account? Do you have cash in your pocket? You want to make sure that if you have, retirement assets, are there beneficiaries designated on that? Because if you don't and you forget to designate someone, then you want to have a will so it says where it goes. A will is just not something that you set to do, when you're at a certain age or when you reach a certain amount of assets. You just want to make sure that you have a plan in case you pass away, period. I have many estates where things come into the estate that people don't plan for. For example, if they didn't get a refund from a tax return or a medical bill. A medical office was due to pay them a refund for more than their premiums or a bill of some sort. It comes into the estate at some point. So you want to have a will to say where it goes.
Okay, so because some people be like, I'm too young, I don't need a will, I'm not dying no time soon, and all this other kind of stuff. And then when we talk about assets, I mean, you point out like a truck, a car, or a house or something. Some people, I think, forget that their children are assets too.
Well, yes, children. Well, they can.
My baby's an asset.
Right, I know. For all the bills we pay, but yeah. So. What's most important about children, especially if you have minor children, is you definitely want to make sure that you have a plan, because a lot of people don't know that minor children can't inherit any money outright. So we can't write a minor child a check. What bank account is that going into? They can't get a bank account on their own. So if you go to the bank and you want to open up an account, they want someone who is at least 18 years old to sign up for them. It's the same thing when you pass away. In the state of Maryland and D.C., you can choose how you want your minor child to inherit, or any minor beneficiary. So you can either choose for them to inherit in like a custodian account, just as I explained at Bank of America or some other bank. You can also decide whether you want them to receive an inheritance in trust. And basically what that means is you're naming someone to hold the money for them, manage the money for them, and the trust document essentially says they can get it at a certain age or when they have attained, their college degree of some sort. Just to give you my little bit of information, what I have in my document, my child is not getting anything when she reaches 18, because 18, you think you're going to marry somebody, they're the love of your life, you're not going to remember their name 10 years later. You think you have a best friend, you want to give, everything to your best friend. So I made sure for my child, she will get a third when she's turned 21, a third when she turns 25, and then the remaining when she turns 30. So I have different intervals where I expect that she's going to be at a certain place in life where she'll be able to handle getting that sum of money. It's not much, but it'll be something.
And I think that that's good, only because I take and think about the situation that happened. My mother passed in October 2017. So I'll be asking you a question about houses and things when you're joint owners with a house later on. But I didn't have to give anybody anything. But I did. I was nice. I split up certain things. I gave some to my sister. I gave some to my auntie because she took care of my grandmother, and then my other auntie and her children. Well, my sister, I wish I could have somehow made it so that she couldn't use the money, because she told me basically, if you give me the money or just keep it. But this amount of money was gone in like 3 months.
Yeah.
3 months. So that whole thing about breaking it up and having certain, I like that idea of that, when you graduate from college, then you'll get this, and you got to have certain things that you have to accomplish before you get the different pieces of the money.
And it doesn't necessarily have to be a minor. It can be an adult. If you have an adult beneficiary you feel like is maybe hanging around the wrong people, or they're not fiscally responsible, you can make the age range or however you want. You can make it where
75.
Look, now I will say if there is work involved in doing that, because you got to file tax returns and stuff like that, but to the extent that you want to make sure you have a plan for them, and sometimes it does depend on how much money you're really talking about as to whether it's worth doing that. But yes, you don't have to do it when they're when they're minor. You can do it as an adult too.
Okay, guys, y'all are like popping the questions in there so quick. I'm trying to scroll up and I'm going to get to them. But I want to remind you, number one, everybody on here, I need you to share and invite. People need to hear this. Number two, I want to remind you of the number on the screen, 301-429-9247. You can call in and ask your questions too. But one of the first questions, I'm going a little bit out of order. I see we have Miss Charlene Shapless asking, do you do LGBT planning?
Yes, and in the state.
What is that?
So it's in the state of Maryland for any same-sex couple or anyone in the LGBT community. There used to be more of a focus on doing it because same-sex marriages weren't recognized. Mm-hmm. They are now.
Oh, okay, that's what I'm saying. They don't recognize that?
In the state of Maryland, there's not much of an issue with that. So we don't have to separate that out from the estate planning categories like we did before it was recognized.
Okay. Mm-hmm. All right, Charlene. Good question, lady. Hi, Cheryl Washington from North Carolina. Thank you for joining us. We have a Mr. Ed Jones coming on, and he's saying, what are the consequences to passing without a will? What does that due to the survivors legally.
Okay. So I'll just use Maryland as an example. If someone were to pass away without a last will and testament, first the law in the state of Maryland will indicate who their beneficiaries are. So in probate, we're only looking for assets that are in your sole name that do not have a beneficiary designation. Okay, so let's use someone passes away and they own their house and it's only in their name. Mm-hmm. If their surviving beneficiaries or heirs at law are their spouse and their children, maybe they don't share the same children, so this is a blended family here. It's not automatic just because you're married that your house is going to go to your spouse. That's not how it's going to work out. It'll actually be split 50-50. So your spouse will get 50% share of this particular house, and then 50% will be split amongst your children.
So what happens with blended families, though? How does that work out?
Well, the only issue with blended families is because it's a blended family, the issue is once that person that was keeping the glue together and the family has passed away, it causes a lot of emotions to become involved in the estate administration process, and it makes it more complicated than what it actually is. So with that same example that I used of the house, maybe you and your spouse are living in that house for 20 years. Next thing you know, if I'm a child and that's not my parent, I'm knocking on the door like, where's my inheritance? Like, I'm, love you, but, I'm due my inheritance, and that is rightfully so. Legally so, that person is. So you want to have a will because you want to say if you want to split your assets up between your children and your spouse, but maybe you want to let your spouse live in the house until, they remarry or they pass away. There's ways to go about doing that, but you can't do that until you have a will.
Okay. Now, so I have one friend that just says she's dependent on that her new spouse, no matter what, is going to do right by her kids.
That is the
and these are minor. These are minor kids. Mm-hmm. They're blended family, minor kids. I could just put his name on everything on the will. He's going to do right by my kids. What's your recommendation on that?
Well, that's a fingers crossed, wait and see approach. You're going to be gone. So you're not going to know whether that actually plays out the way you have set into place in your will. So I usually say, look, don't do it that way. You're not going to, they may meet somebody, after you passed, and they may get remarried. Next thing you know, your entire inheritance is going to someone else you've never met. So that you that you would not have wanted them to receive. So it doesn't hurt to name your children. There's nothing wrong with that. I mean, your spouse would understand that as well, unless obviously there are assets that they have, helped you pay for. Then you can look at your entire estate, not just the house. Let's look at life insurance. Maybe I want to give some cash to my children in life insurance, not in the house. We can look at different types of assets to figure out how you want to designate who to get what, and that would probably be the best answer to that response, to that question. Mm-hmm.
Okay, all right now, because I had, I'm not going to tell that story. I'm not going to tell that story. Okay, so let's see what other questions we got that's coming from someone's asking questions. Oh, living will versus a living trust. What's the difference?
Okay, so a living will is, let's start with this. A living will is part of what they used to call, it was now called your advance directive. So it's actually medical related. It's not like your last will and testament. I know both words have the word will in it, but it's not the same. So we have an advance directive that talks about naming someone to make health decisions for you. There is a Part A, or what used to be a Part A, Part B. Living will was one of those parts. Mm-hmm. We don't separate them anymore. It's now all called advance directive. Okay. So that just made sure that you designated someone and made decisions for what you want your agent to do in certain medical conditions. Now, your trust is basically a merge of your last will and testament and power of attorney form, because basically it's an agreement. It's a document that you designate who you want to make decisions in the event you become incapacitated financially, like a power of attorney would do. And then it also says, go to page 5. If I pass away, this is what I want you to do with regard to my assets, like a will would. So it is more expensive because it covers both aspects of your life. Some people have them and then they don't use them right, because when you have a trust, you also have to make sure that you are designating or retitling assets so that the trust actually owns something.
Okay.
Okay. If it's not attached to anything, it's just a document you're walking around, just paper. So you have to make sure that you're actually retitling certain assets so that when something does happen to you, all the assets that are named or titled on the name of this trust will be operated by the agreement.
Okay, we got Miss Charlene saying that in her case with her father, the wife told the courts that they had no children. What does a person do with that?
Well, it happens. I have not been a part of any estate that has happened. But if you find out that you are in some way, shape, or form in error to an estate, I'm hoping that you find out in a timely manner, because you can force a personal representative to basically name you as an interested person, include you in the estate proceedings. Sometimes they're not going to be able to do it willingly. You might have to take them to court to do it, but there are avenues for that to happen. There are actually heir searcher companies that will go out there and find people who are part of your estate. They sort of have to know that, that you are a beneficiary, but they do pop up, and they will send you a letter too and ask to hire them to help you with the proceedings, since they've told you that there's something going on that you may be involved in.
Hello, Fraser from Edinburgh, Scotland. We got Scotland in the house. Thank you, Scotland, for turning in, sharing the bite. And remember, locally, guys, you can call in on 301-429-9247. Hit that share button down at the left side of your screen for me. Okay, so tell me, when you talked about assets, is there a minimum amount of assets that you should consider before having a will? I mean, if I only have like $10 in my bank account, do I need a will?
Well, okay. We're talking to everyone, the $10, okay. No. What I will say is this. Well, I'll tell you why. If somebody walked into my office and they could barely afford to get a will, they just want to pay for the advice.
Go ahead, Nicole. Tell them. If you can't afford a will, don't get a will.
But there are ways to go about doing this. So a lot of people will designate beneficiaries on like their bank account. That's a way to make sure that your asset goes to someone you've named. So remember, your will only controls things that are not designated or that are in your sole name. So another way to actually making sure that your assets go to someone that you name them. Banks have, paid on death beneficiary designations. It's just a question of when you go to an attorney, you're not just getting information about, general information I'm giving you right now. We're giving you information about your particular estate. What are your goals? Can you achieve that by just filling out a form at Bank of America again? Or some other random bank.
Is Bank of America your bank?
That is my bank. I don't want to give them kudos, but
PNC.
Right. Or any bank. So there are ways to go about planning your estate that are just not in a will. You can do it in a beneficiary designation, just like you do for your retirement assets. Your 401k, 403b. They want to make sure that you name someone. It's the same thing as estate planning. You are doing some form of estate planning.
Okay, so we did the living will versus the living trust question. Is there a difference between a living will and a last will?
Yep. Again, living will is just related to medical care. It's within your advanced directive. So I usually tell people don't use that word anymore. Because it doesn't exist.
Okay.
The name is advanced directive.
Okay.
And in the state of Maryland, District of Columbia, we have an advanced directive. Basically, you're naming your agent to make health decisions, and then you're also indicating what decisions you would like for them to make for you when you can't make decisions for yourself. Your will is purely when you pass away. There are two different documents that come up in different times, one during your lifetime and one when you pass away.
Okay. Now, a lot of people know that they could go on the internet and they could download a will kit. And they could do a do-yourselfer, although, do you happen to know the numbers of how many people don't have wills?
I don't know a lot of people. Let's just say a lot. I'm going to go with that. Because everyone knows that they have to do it. They should be doing it. But it's just not a priority. I'm not sick. I don't want to talk about it. It's not, I don't want to, bring it to life. So I encourage the conversation while you are well. Because you're clear-minded, you're not, making irrational decisions. However, a lot of people don't have them. Yes, I get this question all the time. Every seminar that I've been through, every conference that I've been through, people walk up to me and say, why can't I just pay for it online? You can pay for anything online. You don't have to have an attorney to help you with anything. If you wanted to sue somebody, you can do it on your own. You don't have to hire an attorney. If you wanted to do your own will, you can do it on your own. You don't have to have an attorney.
You can do your divorce on your own.
You can do your divorce online. The question is, are you getting what you pay for? If you're doing your will through one of those companies online, it's not interactive. They're not asking you enough questions. They're not going to use that answer to say, light bulb, maybe she may want to go down this route. It's not like that. It's different screens. You just click the screens. They're going to produce whatever document they think that you want to pay for, and that's it. They're not going to question it. You won't find out if it works until you're gone. So,
and you won't know then either.
Yeah. Okay. And so what to take away from that is you're not paying for the document. When you come to an attorney, you're paying for the knowledge. You're paying for my brain. For me to tell you that I understand what your plan is. I've seen this plan before, or maybe I have another option for you to be able to get to achieve your goal without, paying for, a more expensive estate plan. You're not going to know that till you have a conversation with someone like an attorney.
So when you're talking to people and they do come into you for a consultation or something, what is it that you utilize to determine what makes an adequate plan for their estate?
Okay. So when someone calls my office to set up an estate planning consultation, first, mine are free. So I always encourage people to set up the conference because it's free. Information is key. You want to make an informed decision. You don't want to be making a decision based on, an hourly rate of someone charging you for an hour and they know they're getting paid regardless. I don't know if you're going to come back to me, but at least know you're walking away with information, and it's information you didn't know when you came in. So when you set up an appointment with me, we send you a chart basically to fill out that allows you to tell me what your assets are. I don't want to know what your assets are just to tell you how much I'm going to charge you. I want to know what your assets are so I can explain to you based on the goal that you have, how can we accomplish that. Some people have assets where we need to talk about tax planning. Some people don't. Some people have a goal, and based on the assets, I can tell them how their assets fit into that goal and how we can make it work.
Okay. All right. Now, my auntie, and I should invite her on here. I gotta get her on here. My auntie came to the firm because you guys were nice enough to offer to our union members one year that you would do courtesy wills for 30 days, right? One of the members said they need to do that thing again when they saw that you was going to be on my page. But you were nice enough that they actually did a will for my aunt. Aunt D tore it up because she feels that it was too much information and it was too many pages. It just seemed too much. So I know when I had yours, I swear it must be about
10
pages. I don't know. I got a couple of copies. I think about 50 pages, Nicole. I don't know. That folder I got is pretty thick there.
Okay.
But so I mean, because you have more knowledge. She's like, it's just too much stuff in there. It just doesn't make any kind of sense. So what are we putting in there, and how do we help a person understand that this is something that you really do need? Because she done wrote something on her own.
Gotcha. Okay, so look, the amount of pages doesn't indicate that it's a good or a bad will. However, it's obvious if you only have a 3-page will that may not cover everything that you need. Okay. Any drafts that we send to a client, we always say, I know you're not going to know everything that's in there, because some of it is legal. It's legal wording. It's not layman's terms. So call, schedule a telephone conference. We'll walk through every clause in there, and I can just tell you briefly, this is what this means. This is why it's in there. There are boilerplate clauses that every will has. And we always make it a little bit easier for the personal representatives to be able to do things when you pass away without requiring the court to approve it or court intervention, because it costs more money to do that. So we always add extra language. If you're a person who doesn't like extra language, I mean, it just depends on what your goal is. If you ask for if you have a lot of requests and you're looking for a 3-page will, then I'm not the attorney to do it for you, because I want to make sure it's done properly. You're paying me to do something for you. I want to make sure it's done right. Otherwise, I'm a disservice to you.
I'm so good. Aunt D, I just invite you. I hope you get on here. I'm so scared about what she has in this piece of paper there, because she thought it was just too cumbersome. So, with regards to your children, some people think that, okay, so the house is under my name. You already spoke to it. Doesn't just go to your children. Can you just add? Okay, if someone just adds their child to their deed,
well,
are they protected? No will, but I add my child to my deed. Does that mean my child gets my house?
If that's your goal, yes. If that is your only concern, yes. I have a whole article that I wrote about this particular question because it comes up very often. A lot of people will try to add, children to the deed to their home just to bypass probate. First, my question is, why are you doing that? Why are you scared of the probate process? What is scary about it? I can see if you lived in different states, maybe California, New York, Florida, where probate estate is very court intrusive. You have to go to court a lot. Mm-hmm. And in Maryland and DC, I don't go to court. I send all my documents via mail. It's very administrative. It's very streamlined, so you don't have to worry about that. So I was trying to figure out, what is your goal? Why are you doing that? When you do that, though, you need to be worried about your children's creditors. Because if your child has a creditor and they're now on the name to your deed, then they have an asset.
So that creditor can put a lien on your house?
Why? It's not yours anymore. You've added people, so it's no longer yours.
Uh-oh.
So, what if you need to go into a nursing home and say it's 5 years within, the date you need to go to a nursing home? You're not going to know for sure. But if you're in a condition where your health is getting worse, then you may not want to do that, because that may be, a gift that you made to your children that may prevent you from getting Medicaid benefits, if you can't afford to pay for the nursing home care out of your own pocket. There are just so many. Now you made a gift of over $14,000 that you need to file a gift tax return for. Why do all these things?
Well, you know what? I never even thought about that, so I thought I would ask the question. But in my case, though, that was an easy thing. Remember I said with my mother, everything was mine. I didn't have to give anyone anything because my name was on the deed. But for me, the only reason why my name was on the deed is because my father was killed when I was like 5 or 6 years old. And he left some money. And his sister made it that in order for this money to be there, you want to use part of it to buy the house.
Oh, God, you got it. I got
And she put my name. My name was on there since I was a toddler. So that's a different case. But I never even thought about the whole fact of it could be a lien, the creditors to come out.
And that could have affected your credit in some way, shape, or form. And this is just, say your mother couldn't afford to pay for the mortgage, right? Mm-hmm. And your name is on deed. I don't know if the bank...
it wasn't on the loan, but it was on the deed.
Okay. You're stuck on that title until, unless you sign off or unless, she signs off, I always say don't do that, because you're in a position where you can set yourself up in other ways to document what your end goal is. Mm-hmm. That should not be your first option. Okay. If it's just, I want to make sure that everything is taken care of, okay, get a power of attorney form. Okay. Otherwise, if you want to sell, you got to get all their permission. What if they think that they don't want you to sell it? I mean, just how they got on, it makes it easier. It's harder for them to get off.
I know that's right. Okay. So we had a question that says, what happens to an estate if no will and is contested by survivors?
Well, you can't contest something that doesn't have a will. When you contest in a state where it's a contentious estate, you're contesting the document, the actual last will and testament. You're saying that's not a will because they signed it and they didn't know what they were signing, or they were under the insane delusion that I was trying to kill them, so they didn't want to give me their money. It has to be the document you're contesting. If you don't have a will, you're just going with the state law. So you're not contesting that. Law is a law, and if you wanted to have a will to say anything different, you would get it.
And that's when you get in touch with the register of wills and get into the probate stuff then.
Yeah, so when someone passes away, in Maryland and in DC, we have register of wills or probate court. So you need to file if you have a will, you file it with the court in your jurisdiction. And they will tell you, what type of estate you have, what the deadlines are, because it's not just opening an estate. There are other things that you need to do when an estate is open. Mm-hmm. As a personal representative, you have duties. Who's going to file that last final income individual tax return, things of that nature. So there are other things you need to do. That's just one thing that you need to do, is definitely file an estate, open an estate if you have something.
Okay. Miss Paula Du Bois, thank you for joining. I know you're traveling, and yes, we will leave that information. Paula is requesting Miss Slaughter's information to contact her. Guys, the information is on the screen. You should see it underneath for her name. 301-670-6553 is the way that you can contact Miss Slaughter. So, okay, do you have to have an attorney to file? No. Charlene, are you talking about filing?
Filing an estate, opening probate, if that's your question, no.
Call. If that's your question, Charlene, if it's not your question, call in on 301-429-9247. You done asked about 3 questions. I want to hear your voice.
Right.
I want to know who this Miss Charlene is that's tuning in here. Call in, Charlene. 301-429-9247. I'm going to type it in. She said, yes, that was it. Charlie, you just trying to get out of calling in here.
There's a caveat, okay, to that. I do get people who call when someone's passed away and they're trying to figure out do they need an attorney or not. I actually will tell you right off the bat, depending on what you have, whether you really need me or not. All of my business is based in customer service, so we don't have commercials. You know, it's word of mouth. So if I have a good client, I'm hoping they'll tell me to 2, 3, 4 people. More than that, but at least tell me to somebody, refer me to someone else. So obviously I don't want to charge you if you don't need me. So it just depends on what's involved in the estate, what assets you have. If there's not enough that it's worth paying me for my service, I'll just tell you what to do. But a phone call does change that situation.
Hanging with your girl Tasha. Who do we have and where are you calling from?
Hi, Tasha. This is Charlene. I've been asking questions.
Hey, Charlene.
Hello.
How are you? Go ahead and get your questions out. We're so glad to hear your voice.
Thank you. I met you at an event a couple of weeks ago, so I've been following you ever since.
Well, thank you. I appreciate that.
I've been asking questions. Hey, Charlene. How are you? Go ahead and get your
Okay, Charlene, can you turn your volume down in the background? It's giving us feedback on the call. And what question do you have for us now?
Okay, I just turned it all the way off. The estate planning. Do I need an attorney to file my estate?
And when someone passes away, you're asking if someone passes away, do you need an attorney to file like the last will and testament and open up an estate?
No, I need to do a will.
Okay. So, this is one of the questions that was asked before. You don't need an attorney to prepare a will, but it's advised that you get an attorney to prepare a will so that you understand what you're actually preparing. You know, that what your goal is actually going to be accomplished. Once we prepare a will for you, we always suggest that you file your will with the Register of Wills in the county for which you reside. If that's here in Maryland or DC, because they do offer safekeeping services. So in the event your house is flood or a fire or something, or someone rips it up, you don't have to worry about that. It's filed and it's somewhere safe because your original is what matters.
Okay. Question. So if I have property here, because I'm located here in PG County, Maryland, if I have property here, and then I have property also in North Carolina and Baltimore City, and can it all be lumped here in Maryland, or do I have to go to different states?
Okay, that is a very good question. Yeah, so when you pass away, no matter where you reside, where you are domiciled when you pass away, if you have real property in a different state, you can't pick that up and move it. So it follows the laws for the probate court in that jurisdiction. My suggestion would be for you is actually a trust. Because when you pass away, if you have a trust, any property that is titled in the name of this trust, we just look at the document. We don't have to worry about court getting involved because that's too many jurisdictions. So you're really asking the personal representative to open like 3 probates and filing fees for all 3 of them, paying fees to different entities. Some of those jurisdictions may require, because they're not going to know what to do. They're like, okay, well, let me hire an attorney in North Carolina. Let me hire an attorney in Maryland. Let me hire an attorney wherever else you have property. So I would suggest a trust in that situation, just on the basis of having property in multiple states.
Okay, so, and you do trust?
Yes, I do.
All right, thank you. You will be hearing from me.
Charlene, great question. Thank you for calling in.
Yes, ma'am. Thank you.
Have a good one. Wow, that is a really good question. I know a lot of people that made me excited. I like when good questions come through. Y'all call in because y'all make your girl Tasha happy when you call in with questions. 301-429-9247. So, when it comes to estates, what type of documents should be included?
Okay.
What is your normal recommendations or the bare minimums?
For a basic estate plan, I recommend 3 documents. One is an advance directive.
Get your pen and pencil
write this
and
down.
paper out.
Write
Get
this
your
down.
pen, your pencil, and paper out.
Advance directive, that's a document, again, that we are naming someone to make health decisions for you, and then you're also giving some instructions. So within that document, you can also say whether you want to be an organ donor or, if you want pain medication, things of that nature. The second document is your power of attorney form. This is the document that allows for you to designate an agent to make decisions with regards to anything other than healthcare, so really finances. And then last is your last will and testament. So 2 documents for when you are incapacitated and you can't make decisions for yourself, and then 1 document for when you pass away. That is your basic estate plan, covering all bases: health, finances, and death.
What was the third one?
Last will and testament.
Last will and testament. Got you. Had someone saying that I needed to move the microphone. I was paying attention to that. Okay, did y'all write that down? All right, I'm gonna tell you. We might just have a quiz at the end of the show. Now, your girl Tasha, I'll be doing stuff. Oh, you know what? Matter of fact, I might do a quiz at the end of the show, and somebody going to win themselves a week of supply of organic detox tea. If you can answer that question right, you're going to have to call in here and give me the answer, though. Caller number 3 or something. Act like WPGC. It's like, I didn't say that. It's WBGR, baby. Okay, so, this is like just so much different information. I don't even know what to ask.
Well, let's talk about the power of attorney a little bit.
Okay.
We didn't get into that much.
Yes. Okay.
So power of attorney is helpful. So when you can't make decisions, or even for convenience purposes in Maryland, you're designated someone to make decisions with regard to your assets. So this person would be designated to sell your house, get into your bank account, pay your bills. Some people are very hesitant on getting this document because they're like, look, I'm fine. I don't want to be worried about nobody getting to my accounts. I want to know for certain that I'm the only one that has access.
You gotta trust that person.
You do, and you want to choose someone, one, you can trust, and the other, and second, that is fiscally responsible. You don't want to choose someone who has bad credit. Why would you choose them to handle your finances? But the key is, I always get clients who wait to the very last minute in getting a document such as the power of attorney form, and sometimes it's too late. So for any of these documents, you have to have the capacity. You have to understand what you're signing. You have to understand what you're signing up for. You have to understand who you're naming. And so if you come to me and I ascertain that you don't have the capacity, then I can't draft these documents for you. Wow. It's definitely cheaper to get the documents than to be in a position where you don't have the capacity to get in these documents, because the only resolution or solution for that situation is a guardianship.
All right. I like that, Mr. Stephen Bennett. He's saying thank you to whoever invited him, because he said we are never ready to end the game.
No. But it's a certain end. It is a certain end. You will pass away. There's no question about that. So, you just want to make sure that you're in control of what happens when you're gone. And don't do well, I talk to my spouse or I talk to my children. I've designated, the person I think is more responsible to handle it. When you're gone, it's chaos. Period. I don't care if everyone's in agreement today. We have a family meeting. Everyone's on the same page. When you're gone, that changes the game.
I'm going to have to tell this story. I'm not going to name the name, but we had a supervisor at Verizon that decided to take his life. And when he took his life, he actually left directions about how his child should be cared for, and who the mother couldn't have the child around, and all this kind of stuff. And I'm like, are you serious? So now that's a good thing. Now what happens if somebody has a will and they commit suicide? How does that all play out?
It doesn't have any impact on what you designated in your will. It doesn't matter how you passed away. All that matters is that you have passed away.
Okay.
So just making sure that it is in the format as the jurisdiction that you live in requires is key. Writing something down on a piece of paper, that's not a will.
Okay. Yeah. I was like, I can't believe that this is what this man did. Okay, so I used to be married. I'm not married no more. Mm-hmm. But I know that when I did my first will, because that's why I came to you, so I could do the redo of the will, because we had to get his name about it, the original will, right? Mm-hmm. But when I originally did the will, I tried to encourage my ex-husband to do a will too. Mm-hmm. He's like, what, you planning on killing me? So he would not do the will. Mm-hmm. So I imagine that having that discussion, whether it's with a spouse or even with parents or something that don't want to have that discussion, do you have any kind of suggestions about how you start that conversation to encourage someone?
I do. I always pull at the heartstrings. The purpose of getting the documents is to make it easier for you as the child or you as the spouse when someone passes away. You know, essentially them saying, no, I don't want to get it is basically you're knowing that you're setting yourself up for chaos. So it's just best to have a family meeting if you can. Even though you're having these discussions and you're on the same page, and you want to formalize it. That's it. Put it on paper. Don't go with, I'm telling you you're going to do it, because when you're gone, someone's going to fight that. Someone's going to fight the, oh, well, I know she told you, but, we don't think that you're the best fit. Why do that? Why go down that route? Go ahead and get it in paper, get it in writing, and it's official once you do that.
Okay. Any other things that are normal that you can think of, regular questions that everybody comes in, or special what's your, pull it on the heartstrings. If you tell a horror story, sometimes horror stories make people think. So give me what you can think of your worst horror story for a family that did not have their things in order.
I have two. So I'll do a horror story about someone who did their will on their own. I had someone who passed away. They prepared their will on their own, and it wasn't a matter of finances, because this individual had more than enough money to pay for their own last will and testament. They just chose to do it on their own because they were going on a trip, and they're like, in their mind, if our plane goes down, I want to make sure that everything is lined up. Well, they're typing into their online form with this scenario in mind. But I think halfway through, this person forgot about the original scenario he actually started out with. Because at the end, what ended up being the result is his wife was on the plane with him, so he's thinking, we're both going to be gone. So I'm not going to name her to be the personal representative or executive. I'm going to name someone else. But then at the end, she's also a beneficiary, so I think he just forgot. In any event, what ended up happening is his parent ended up being the executor or personal representative, and that individual did not get along with the spouse.
Oh, Lord.
When I say didn't get along, I mean, you can't be in the same room, we can't have a conversation, nothing. Anything needs to be in writing. And so with that being said, this individual had many businesses. We had millions of dollars were involved. But they ended up paying hundreds of thousands of dollars in attorney's fees just because it wasn't clear. Just because, if you have someone on the other end who doesn't trust the person that's managing the estate, there's going to be lots of phone calls. There's going to be lots of, I don't think that's right. I think there's something else going on. And there's just a lot of conversations to just ease
I think he killed her. I'm sorry. Have you heard that one before?
Listen. In any event, it was a worst case scenario because he could afford to do it. He just chose not to, and you ended up paying more money anyway. Mm-hmm. Because you didn't go to an estate planning attorney to advise you as to what you were doing was the right thing for your plan. Don't assume you know. I mean, unless you went to law school and you practice estate planning. And I will say there's a lot of attorneys out there who try to do their own. Attorneys, we are our worst client. Because we will think
that's
that
like a union rep. You in trouble, you go in there and try to represent yourself.
Yeah, no. I know that if I needed, a civil attorney, a criminal attorney, I would never be in that case. But if I'm going to hire someone with expertise. I'm not going to try to do it myself. But if you think that you can, you're not going to know. You're going to figure it out. Your family's going to figure out when they pass away and they get that bill. So I would just encourage you to get the documents. You don't have to worry about that. Second example of a client that I had who didn't have a will. Most of my clients who don't. One client who didn't have a will. She had named an ex on her life insurance policy. So when she passed away, she didn't have a will. We went with what the state of Maryland had. But her family was like, if the state of Maryland has this law in place and these are our beneficiaries, why is it that her ex gets this life insurance policy? If you came into an estate planning attorney, I'm looking at everything. I'm asking you who your beneficiaries are. Again, I'm getting into your business, not because I, want to know, but I have to know in order to advise you. And if she would have came in, I would have told her, if you want your plan to be X, Y, and Z, then C named on your life insurance does not fit into that plan. So part of your estate plan is just not that one document you're zoned in on getting. Not just your last will and testament, not just your power of attorney, not just your advance directive, but every document that you signed up for in your lifetime where you've named a designation for a beneficiary, that's part of your estate plan too. So it's looking at the bigger picture of all of your documentation as well.
Okay, so we have a question that's saying, what's your thoughts basically about the estate of Prince and how that applies to an example of not having a will?
Yeah. If you are a person who may have children out there that you may not know about, you want to get a will because your beneficiaries are locked in. You know, they are X, Y, and Z. Mm-hmm. If it's open-ended or if you don't have one, it's paternity tests that are ongoing forever. Now, what happened in Prince, I believe at some point the judge locked it in and said, if they don't come forward by X date, that's it. Because everybody was claiming to be a child of his. So, again, here's a person who has the means to get estate planning documents done, but chose not to. So if you know that you've seen examples like this, and you know what the consequence was of not having had a document, it's already something you've seen. It doesn't have to attach to you. It doesn't have to be in your family. You already see it. It's happening to people out there in the universe. Why would you not get it?
Good question. Someone asked, also, are wills appropriate for, say, college graduates or new jobs overseas? With a new job, college graduates with a new job and it's overseas.
Oh, absolutely. Well, I'll say this. If you're overseas, you want to get a will that will be recognized in that jurisdiction. So maybe you may want to seek a estate planning attorney in overseas because your will is not going to attach, you know. If you have property over there, and this is an example for, you know, maybe that graduate buys a piece of property. Mm-hmm. You know, that property, remember, we can't pick it up and move it.
Right.
So that's going to be under the jurisdiction of where that property is located. Now, obviously, they're going to have bank accounts and stuff here, so you want to get a will here regardless. But what's most important is not only passing away, but again, if something were to happen to that person, what if they get sick overseas, right? Who's going to pay their bills? I'm assuming they have some student loans, so they make sure that get paid. Maybe, maybe not. What if they have medical bills? You know, you want to be able to call the hospital. Who gives you the authority to speak to somebody on that person's behalf?
Okay, that made a question pop in my head then. With all this talking about how you have to have the will going based off the law of where you live at, what do military families do? They are jumping all around all the time.
They have wills, military wills. Okay. And there are attorneys who are specifically JAG attorneys. They're for the military. So they understand the laws with regard to what is required for a military will. Mm-hmm. I'm not one of those attorneys. Okay. But a lot of people who are in the military have that service, and I believe, and you know, I'm not going to say for certain, but at least one or two people that I've met who came to me after they've had a JAG will done, they can get that service done through the military, and I don't think that there's a cost for it. Oh, okay. If there is, it may be a lot cheaper than coming to a private attorney. But you want to go to a military attorney because they know the laws with regards to the military and how that is concerned. Okay. Yeah. So
you threw out Bank of America name a lot of time. I had to throw out PNC. That's my bank. Mm-hmm. You know, I left Bank of America. Bank accounts. As far as the cash that's left over in that, if you have, is it good enough for you to just put somebody else's name on there? Does that mean that they automatically will get the money?
Oh yeah, so mind you, you add someone's name on anything you have, it's theirs as well. Why would you do that? If your end goal is to make sure that someone gets something when you're gone, why are you adding them onto your lifetime to have access to it right now? Right? Sometimes you have to think about what your end goal is and why you're doing what you're trying to do. Okay. Because it's not matching up. If the concern is you want to make sure that they get what's in the account, again, you can designate a beneficiary, you can get a last will and testament. If your concern is I want them to have access to the money when I pass away, you know, pay funeral expenses and things of that nature. Look, when you pass away, technically, legally, no one's supposed to have access to your account, write checks and things of that nature. So your account may or may not be frozen. Maybe you want to pre-plan your own funeral. It is really best that you do that. A lot of people don't do that. There are some that do, and the people that pre-plan their own funeral, they don't have to worry about a grave site being picked up. They're picking out their own stuff. They know how much it costs. They're pre-paying for that because they don't want the burden to be on their family to figure out where the money's going to come from. So if that's your concern, why don't you do that? Or why don't you leave some money in the life insurance policy? Give them a certain amount that makes sure that it gets paid. But once you add them on the account, how am I supposed to know that that's actually what you were intending them to use it for? They may get onto the account and take the money, and that's it.
Okay, if a person dies and they have a lot of debt, is there some way that the will protects them where the family doesn't have to pay the debt?
Well, first of all, having debt and actually acknowledging the debt as an official debt, two different things.
Okay.
For my personal representatives in my estates, I always say, there is a law that allows for creditors to file a claim against the estate. In Maryland, it's 6 months after you pass away. In D.C., it's 6 months after someone's been appointed as personal representative. In any event, that is the time that they have legally to fill out paperwork and say this person owes money. If they don't fill it out within a certain amount of time, it's not a legally valid claim. So why are we paying it? In our lifetime, we're worried about credit, right? We make sure we go to the credit store. When someone passes away, there's no credit. What are we worried about? They're gone.
Girl,
what are you rushing for?
You know what you done made me think about? When my mom passed, I called Verizon to shut down my company. Yeah, Verizon, my company. I called Verizon to shut down her phone bill. This chick want to tell me that the bill still had to be paid. I told her to go to Fort Lincoln Cemetery to the Garden of Eden and go ahead and send the bill over there to her to get it because I wasn't paying the bill. I couldn't believe that that's what she was trying to force you to do.
And some people will try to pull you into that conversation. And once you say, okay, I'll make sure you get paid, not right now, you're locked in. Once you make a promise, you're locked in. Mm-hmm. So I usually say, hopefully you have an attorney. Because clients don't like to say, don't like to be in that situation. So I would say, just tell them to call me. Then I'll tell them, Then there are other clients where the 6 month period is passed. And someone is now calling them about, a bill. But they want to make that phone call and say, we don't have to pay you. You lucked out. That's it. You missed that period. We're not paying anything. And you're legal allowed to say that. That's their job. It's their opportunity to file a claim, not yours. You don't tell them what to do.
All right now. Go ahead. Y'all could just have $1 million in debt and not have to pay nothing. I'm about to run everything up. I'm crazy.
Now you want to make sure there's no cosigner involved. That situation is a little bit different. But if it's just in your name by yourself and there's no cosigner attached, then why are you worried about it? It's not yours. Don't take it in as your own debt.
Okay, well, a lot of people are saying that they definitely want to use your information. They see your phone number on the screen and stuff like that. Can you tell them where are you located?
Okay, so we have many offices. Our main offices are Gaithersburg, Lutherville, and Frederick. However, we have local offices in Largo, Cumberland, Virginia, District of Columbia. So depending on where you live, I will find an office that's closer to you. We also have Columbia and Annapolis. Let me forget those. So I will work out where to meet you. What's important is that you call me first. Let me know where you live when you schedule the appointment. It's free. So let me say it again. It's free. Call me. I want you to be informed. I want you to make an informed decision. When you leave my office, it's up to you to decide whether you want to retain me or, maybe you say I have your information. It was free. I may want to do something on my own. I'm not going to show you how to do it, but we will talk about, what I offer as far as my services, what's the best plan for you. The young lady called in and explained, her situation. I was able right off the bat to tell her this is what my thoughts are. You will also talk to people who will come and tell you what they think your plan should be. People come in my office all the time and say, I want to trust. Someone told me that's the best thing since sliced bread. I may tell you that it's not worth paying for that. There are attorneys who may say, no, you should get that because you're paying more on attorney's fees to do it. Mm-hmm. But again, I only make my clients or call me, refer me to other clients, and that's how I make our business successful. So call. The consultation is free. We will discuss what the fees are at that point, depending on what you have and what you need. Yes, people call me and say, well, how much is this and how much is that? I can give you a random amount, but depending on what you have, I don't know if that's going to apply to you. But I will say that our fees are reasonable if you compare it to other firms. I made it that way because I want you to come back to me. So hopefully you do give me a call, 301-670-6553. And that is my direct line. You're not going to get the receptionist.
Okay, so I have a question that I can't see the whole thing because every time I hit it, the little band want to talk something and pop up. Oh, okay. Do you foresee a time when employees will make estate planning, if not mandatory, at least a part of a new hire package? Can they do that legally?
Well, there are some. Well, I don't want to say it's an employer thing, but there are some companies where they want you to make sure you have beneficiaries filled out, because they want to make sure on their end, if something were to happen to you, that they don't have to go about the legalese of trying to figure out who is the right person to talk to. I don't think that that's going to become a mandatory thing, because they're not attorneys. Why would you even trust them to give you any information? Just like, you're supposed to do something, right? You're supposed to get an estate plan. You don't have one. So you clearly have questions. That's the reason why you don't have one yet. I'm assuming that you're not, making the assumption that you know what's going to happen to you when you pass away. That employer can't answer that question. I mean, I work at a law firm, and they don't give me legal advice as to, who my beneficiary should be. They just say, make sure you name somebody.
Okay. Can we make sure we get Nicole's number back up on the screen for us? Everybody knows if you want to call in and ask a question, it's 301-429-9247, 301-429-9247. So we have roughly about maybe another 5 minutes. If there's anything and everything that you think that we haven't covered that would be important for the viewers to know.
Okay. I haven't gone into details about trusts. I gave a little bit of information. It's more of an advanced estate planning tool. But basically what it does is allows a person to avoid probate. So you're not going through the court system to make sure your assets go to whomever you're naming, like your will would. You're actually just retitling your assets, making sure that they're titled under the name of your trust document, and just following the trust agreement. As to what to do with those assets, depending on the situation you're in. It is a little bit more expensive than your last will and testament. The reason why that is so is because you're paying up front for the document, so you can save money on all the probate fees that will be involved. Mm-hmm. You may or may not need an attorney for that, just like you may or may not need an attorney for an estate. So there's no pros and cons to that effect, but depending on your estate plan, somebody may want to do it for convenience purposes if they have a lot of beneficiaries, or again, they have real property in multiple states.
Okay.
Mm-hmm. And then another thing that I didn't touch on is guardianship, which is a whole different topic altogether. But basically, if you don't have a power of attorney form for someone to make decisions with regard to your finances, or an advance directive, and you can no longer make decisions for yourself, the only option is the guardianship. Very expensive. I will tell you right off the bat, our retainer is $2,500. That's just a retainer. So it is way more money to do the wait and see approach and hope at some point that you can get the documents, because usually the children are bringing the parents in at that point. And it's sad, but I sometimes have to say I can't do that. This is your only option. And in that respect, the court is involved. You have to get appointed through the court. There are things you have to do when you become appointed to keep the court involved in as to, what you're spending money on, what the person has, things of that nature. Don't get into that. Pay for the documents before you get to that point. Don't do the wait and see approach.
Speaking of children, if you're in a situation where definitely you have two parents, one has a will, one doesn't have a will. Mm-hmm. And they talk about them getting into a car accident and one dies before the other. What happens if they determine that the person with the will, who may have left the other parent as the guardian, died first? Okay,
as the guardian, so I'll tell you, there is also, if you don't have estate planning documents like your will to name who you want as guardians when you pass away. Mm-hmm. Again, the law in your jurisdiction says here is the hierarchy of priority as to who can become a guardian for an individual. So if more than one person wants to be the guardian, as many of them will apply, and the court will name whomever. Again, it's best to name someone. It's not as soon as you name someone, that person is definitely going to be it, but it does give someone a one leg up in the process to say, that person chose me. I obviously was a good candidate because they chose me in their document. The other person's not going to have anything else to say that they would have gotten chosen. So a last will and testament does help that. Mm-hmm.
Copies of your will, who should you give them to?
Well, that just depends. Some people don't want to give them to the people that are named in their documents because they don't want to be looking over their shoulder.
We talked about that earlier.
Yeah, some people do because they're, they want everyone to be on the same page, so that they want to make some noise, they make noise now. It's totally up to you. There's no right or wrong. There's no right or wrong. But your original, you do want to keep it in a safe place, whether it mean filing with the register of wills in your jurisdiction or a safe. I avoid safe deposit boxes altogether. I don't think that's a place where you should keep your will.
Lord have mercy. I think my aunt got hers in a safe deposit box too.
Oh, good. Yeah, you may want to have her.
I have to have her talk to you now.
Yeah.
Okay. All right. We're going to have her talk to you.
Okay.
Because she moved past, and like I said, I asked her when I posted that, I said, is Nicole the one who did your will? She said, no, it was a guy there.
Yeah, it's probably Jeff. But if she had me, she wouldn't have ripped it up.
Oh, okay. So, I don't know. Ooh, Jeff. Ooh, Jeff, did you hear that? Anyway, Nicole, it was such a pleasure having you in the studio today.
Thank you.
I hope that this helped the viewers and a lot of your questions got asked. We want to remind you that if you have questions or you want to use the services of Miss Nicole Slaughter, Esquire, dial her on 301-670-6553, and make sure you come back next week because we're going from the different end of this. We're going by having the register of wills here so they can ask questions. So, it's just about educating everybody in the community and making sure that you guys go out and do what you're supposed to do for yourselves. So, we'll see you. I appreciate that. This is so exciting.
I know.
She's been on the schedule for a couple of months, and the day is finally here, and it was exactly what I thought it would be. I thank you.
Thank you. Thank you guys for tuning in.
All right. See you next week on Hanging with Your Girl, Tasha. Bye-bye.